and I do have a PowerPoint that I'd just like to share, if I can share it properly, and just go over a number of issues that have, I suppose, impacted on me and why I've done what I've done. And that might provide a bit of a background to why I'm speaking about a Women's Bill of Rights and about the Domestic Abuse Act. I'm just now trying to do a slideshow. Here it is. Yeah. I am a lawyer, and I've practiced at the bar, that is, as a barrister. And some people might say, well, you know, why did you enter into law? What motivated you? And then I've done a lot of travel, and I'll explain that briefly, I hope. And then I've been in law reform, and also I'm a writer as well as a filmmaker. And I'm just learning that my internet connection is unstable. So if I freeze or disappear, I promise I'll come back. And then why organise? And why go into legal practice, and why engage in politics, and what's the future? And the issue about, I'll just go back to why to go into practice and why to go into politics briefly before going into why law and so on. You see, people, and particularly women, say the law is not friendly to women. And I will absolutely accept that. But I also believe that it is possible to have wins through the law, and there is value in the law and the legal system, and I'll come to that. And then with politics, similarly, many women say, why go into politics when we know that there's harassment of women in the parliament and so on? Well, I think that there are advantages of going into politics as well. But why the law? I come from a family where we engaged in debate and had huge debates at the dining table and so on over dinner. And I was in the middle, it was in the dining room, we weren't dining, but I was in the middle of a huge debate with my maternal grandmother, which I won. And she said to me, I was about 11, 12, 13 at the time, look here, Jocelyn, you just have to be a lawyer. And that stuck in my brain. And what I found is that very often that's the case. Possibly it's the case with guys, but it's certainly the case with women, that one word can send you off in a direction, and it becomes a passion that you engage. And that did mean that I entered into law. I had the chance of having a teacher's scholarship and doing university that way, but I just renounced it and went straight into law. Then the issue is, why travel? Well, I've been really, really fortunate because I wanted to travel, but I wanted to travel in a way that meant that I connected with the country that I was traveling in. I didn't want to be, oh, it's Tuesday, this must be Belgium, and then, oh, this is Wednesday, I must be in France. So I went to, this is Southern Methodist University in the United States, it's in Texas. And I went there because I'm originally from Australia, and the university year is different in Australia from the Northern Hemisphere. In Australia, one begins the university year in March, and here, of course, we start in August, September, and of course it's the same in the States. So I went to the States in May, and I had that whole period between May and August, September. So I found this course at Southern Methodist University and went there. I don't know how many on this call can have any idea or memory of, you probably weren't even born, when John Kennedy was assassinated in Dallas, in Texas. Well, I'm sure it's still the same in Dallas, in Texas. If you go there, the first thing that they will take you to and talk about is the book repository where Oswald allegedly shot John Kennedy. He was allegedly in the book repository and shot John Kennedy. They'll take you to Love Field, which is the airfield that John Kennedy and John F. Kennedy and Jackie Kennedy landed. They'll take you to the grassy knoll where it's alleged that there was another shooter. There's a big issue. They'll take you where Zapruder took his film and so on. It's absolutely fascinating. I mean, they are really amazing, the Americans. And the other thing that they'll do in Dallas, Texas, because that's where the great oil millionaires, they're probably billionaires now, are, and the people, they'll take you around and show you all the houses, and that one's worth 3 billion, that one's worth 2.5 million, etc. But anyway, that's SMU, and it was really wonderful. And I do have to say that it taught me something very important about being a woman. When I was at law school, there were very few women and a lot of men. And when we had law school shows, it meant that the guys brought women from the arts faculty because there weren't women in the law faculty. And I used to think, look, these women who are coming from the arts faculty, they're really carrying on in such a daffy manner. Well, when I went to SMU, I worked out what was happening, because at SMU, I'd be in the middle of a really good discussion with some of the women there about Malcolm X and Martin Luther King and so on, because I read all that I could about the African American situation. And we'd be having this conversation, and then all of a sudden the women would turn into daffy human beings. And what it was that a man had appeared on the scene. And that was when I realized it wasn't the women who were silly, it was the social and cultural imperative that women had to pretend that they weren't intelligent in front of men, which was really terrible. But it was important from my point of view, because I have to confess, I had been thinking the women were silly. And then, of course, I realised that they were intelligent, but that this pressure was making them act in this way. Now, that's the University of Michigan, where I went to next. That's in Ann Arbor. And that was really beautiful too. I lived the one down below on the right-hand side, that's the library. And I lived opposite that in the law quad. And we know that America gets a really bad press in so many ways, and what's happening there at the moment is terrible. However, in the law, when they're good, I have to tell you, they're absolutely brilliant. And the Earl Warren Court, which was the one that decided, Brown and the Board of Education, about the equal rights of African Americans, and Miranda in Arizona, where it was decided that the police had to give the Miranda warnings. That's where the Miranda warning expression comes from Miranda in Arizona, a case before the Supreme Court of the United States. They have really, really good brains. And the other thing about the Americans is that they will not just say, if somebody comes into their chambers or their office or whatever it is they call it there, and with a problem, don't say, there's nothing we can do, that's, you know, what the government does, etc. They will endeavour to work out how it is that that client can actually be assisted. Now, that means, of course, that they can have a client come in who wants to evade tax, and they'll sit there with their tax lawyer, they'll start working out how they can help them evade tax, which I would not agree with. But if the person comes in with a human rights issue, then they'll sit there and endeavour to work out how it can be addressed. They won't just say, too sorry, too bad, can't happen. This is Girton, because I came to Girton next in Cambridge, and that was really beautiful too. However, what was interesting was that I probably came the wrong way around. I should have come here first and then gone to the States, because by the time I was in the States, I'd been in the States. This is the inner temple that I belong to now. But when I was in the States, you see, I was alerted to this really, it was a confirmation of how I felt about the law. When I was at law school, I knew there was something wrong. I knew that the law was unfair and unjust and had to be used to effect positive change. And when I went to the States, that's where I knew that I was right and the law could be used in positive ways. But here at the University of Cambridge, when I was there, I went to seminars with Glanville Williams, who was seen as the doyen of the criminal law, and I'm afraid it was not as enlightening as it ought to have been. Anyway, that's another story. Now, opportunities, I've had tremendous opportunities. You see, I had all those travel opportunities. I did it on scholarships, and I had the opportunities. I was a High Court Judges Associate. That's like being a Supreme Court Judges Associate here, or a clerk to the Supreme Court in the United States. And that was a tremendous experience, because the judge that I worked with treated me as if I was an equal. And to have a man treat you in that way, you will all know, is not a common occurrence. And he was not in the least bit patronising. He could see I had a brain. We had discussion about the cases, and he incorporated ideas that I came forward with. And sometimes he'd say, look, too many ideas, we've got to have a through line. And the other work that you've done, there will always be another case that you can use that in. That's a really good thing to remember. I worked for a parliamentary committee, was director of research with the Legal and Constitutional Committee, and that combines law with politics, which was interesting to me. And then law reform. If there's something wrong with the law, action has to be taken to fix it. And I went into formal law reform. It was a government agency, but I also did law reform with women's organisations. We did reform into criminal assault at home and other forms of domestic violence, and rape law reform. And perhaps we'll come to that when we look at the Domestic Abuse Act. Now, barriers and setbacks, it's a male-dominated profession, and it still is. I mean, it's absolutely shocking in this country. There's one judge on the top court who's a woman, one judge. Canada has had a woman as the Chief Justice. They've had a majority of women. They've got 9. We've got 12 here. They've got 9 there, and they've had 5 women on their court at one time. The States has 3 at the moment. They've had 4. Australia has a Chief Justice who's a woman, and they've got 7 there. It must be 3 out of 7 are women. Aotearoa, New Zealand, ages ago, had a Chief Justice who was a woman, and they had a Chief Justice who was a woman. They had the Prime Minister was a woman, and the Governor General was a woman. And that's back in, must have been the 1980s. Of course, they've got a woman as the Prime Minister now too. But because the bar is very male dominated, one of the advantages of it is that if you work in a male dominated profession, you actually get to know how they work and how they operate. And it's not a bad thing to know that. And if you walk into a room that's dominated by men, then it's something to which you're accustomed. So it's actually easier in some respects to deal with it. But I've had highs and horrors in my career, as every woman does. I won't dwell on that, but I can if it's seen as important in any way. And then I have an Anti-Discrimination Commissioner, which was terrific, because I was the inaugural Anti-Discrimination Commissioner operating this Anti-Discrimination Act of 1998, and it's still the best anti-discrimination legislation that I've seen anywhere. It's way over and above what we've got here. And that they had a provision in that meant that I interpreted it to include misogyny, hatred of women, because the act had hatred of vilification of persons with a disability and of persons of minority sexuality. And because of the way that sexuality was defined to include heterosexuality, then I was able to interpret it to incorporate vilification of women, and had cases on vilification of women. Then, before I went to the Anti-Discrimination Commission, I went to the bar, and that's the best thing I've ever done, because I'll come back to the point that I was making at the beginning. You can make a difference. And when you win, it is a really great feeling to come in front of judges who do not want to go with you at all. They want to find against what you're arguing, and you manage to persuade them. And I'll give you one example. This is not actually a woman issue, but it's an example I can give amongst others. I was in the Court of Appeal, and that's 3 male judges it was. And the issue was that my client had been convicted of murder. He had killed his stepfather. I didn't do the trial because I can see how it really shouldn't have been murder, but anyway, it was. And he did that when he was a minor, under 18 years of age. But by the time it came to sentencing, he was over 18 years of age. And the law had always been interpreted as the age you were at the sentence. If you were an adult at the time of sentencing, then you would go to an adult prison. And we went into court arguing the opposite, that that law had been interpreted wrongly all the time, and that my client should not go to an adult prison. He had done the crime of which he was charged when he was under 18, and the penalty should be according to the age at which he did the crime, not the age at which he was now being sentenced. And those three judges, one of them was the sort of judge who, you know, pat on the head, sweet thing, etc. And you know they're off, they're not, you know, they're no use at all to you. The one in the middle was neutral, and the one on the right-hand side, I'll never forget, fought with me all the way. He had arguments against what I was saying, and I'd come up with something, then he'd come up with something else. And in the end, he was the one who wrote the principal judgment that agreed with me, that agreed with our argument. And the benefit of that is that when somebody's arguing against you solidly all the time, it makes you work out what your arguments are. It puts you on the metal, as it were. And even if, I mean, in that case, he came with me because he could see that what I was arguing was valid and he had to come, even though he didn't want to. It was reluctant. He had to agree with what we were arguing. But sometimes if you're in an argument like that and you don't win, don't worry that you haven't won. It's a bit annoying, but the point is that you've thought through the arguments and you've got all the arguments, and you know for the future what the arguments are that you need to be putting wherever you are and whatever it is. Then I went to Fiji. It's a Pacific Island nation as a judge of appeal. And I was really fortunate again that because when I went to the bar, the guy with whom I read said to me, take every brief that comes in the door. Don't say, I'm not going to do family law, it's all too dreadful. He said, take every brief that comes in the door. And that's what I did. And that meant that I was a generalist. I had to get on top of every area of the law that came in my door. And when I went as a judge to Fiji, I was a trial judge in civil, I was a trial judge in crime, I was a judge of appeal, and I was the chief judge of the family court and the employment judge. And that was because I'd done all the work that I'd done, and I hadn't just gone off into planning or off into family and not done anything else. I could actually do civil and criminal, for example. So
yeah.
what are you want me to finish?
Sorry to interrupt. You know, because we want to really tackle the Women Bill of Rights, because I personally know about it, and I think most of the people that are here probably they don't know about it, and they will really love the concept.
I know.
So I don't know if, yeah. Thank you.
Yeah, I'm coming to an end, and so then, I mean, other opportunities that you can take. The point is that there's serendipity. You do need to take it. And so here I am in Cambridge again, ending up at Lucy Cavendish as a visiting professor. Then I went to Penn State as a visiting fellow, as a visiting professor. And I'm back at Girton again and went to the bar here. So I just wanted to run through that, because it is really important, I think, to see all the opportunities that there are for women, and that you have to actually grasp the nettle. And I know that you've all got all sorts of experience, every one of you, and that you need to stay sane when you're working for world change. And the way that you do it is that close colleagues count, and therefore no one does it on her own. Everybody does it because of all the support that we've got. Now, to a Women's Bill of Rights. Why do we need a Women's Bill of Rights, and why should this country embrace the idea of a Women's Bill of Rights? I'm sure that you all know, whether you were on the planet or not at the time, that 1975 was the International Year of the Woman. And out of that year there was first a declaration of the rights of women, from which CEDAW came, the Convention on the Elimination of All Forms of Discrimination Against Women. It just began as a declaration, and then it was transmogrified into a convention. And that came out in 1979, and this country signed up to it in 1981. In 1986, this country ratified CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. And once it had ratified it, that means that the United Kingdom had made an undertaking that it would incorporate all the provisions of CEDAW into domestic law. Now, I haven't got it on the list there, but in 2004, the country signed up to the optional protocol. Again, I'm sure you know what that means, but I'll just briefly explain it. The optional protocol is that where there's one under other conventions too, but we're looking at CEDAW. If, say, there's a discrimination claim, for example, that a woman has, or something's happened in family law that has come out wrongly, according to the justice of the case, then as long as she's taken the matter all the way up the ladder to through the domestic law scene, then she can go to the CEDAW committee and have the CEDAW committee look into the matter. And if the CEDAW committee determines that what happened in the family jurisdiction, for example, or in discrimination jurisdiction was wrongly decided, they can't overturn the decision, but they can advise the government that something has gone wrong, and then the government may change it. And that has been done. But to come back to the ratification, once there's ratification, then the country should domesticate the law. Now, there's a bit of an irony at the moment in all this. I mean, first of all, 86, 96, 100, 616, we're nearly 40 years after ratification. But if you look at Scotland and Wales, they are both, their local authorities are working really hard on a Women's Bill of Rights, each of them. And there's work going on in Northern Ireland as well. But with this country and the government that's presently in power, Scotland actually endeavoured to domesticate the Convention on the Rights of the Child. And when they did that, the United Kingdom government took them to court, saying that they had exceeded their powers. Now, they haven't managed to cut down absolutely Scotland's power to introduce certain provisions of the Convention on the Rights of the Child. But you see, the irony is that what the argument that's being used to say we can't domesticate conventions is that they say we have to have the agreement of Scotland, Wales and Northern Ireland. Now, here you have a case where Scotland, as I said, Wales, both their local authority, their devolved authorities are working on a Bill of Rights for women, and Northern Ireland, there are women working on it there. And so the government here, therefore, has no excuse to say, well, the other parts of the United Kingdom are not in agreement. And then if we look at what's happened in this country in terms of any women's rights, before CEDAW in 1970, there was the Equal Pay Act, and then other legislation was promulgated that was purportedly covering women's rights. And then if we look at the 1998 Human Rights Act, there are some provisions in that we can use, and the Equality Act, but they're not as full or as good as CEDAW. And CEDAW, of course, is old, but it's been constantly brought up to date by the reviews that the CEDAW committee carries out. So why do we want a Women's Bill of Rights? Maybe I'll hand over to Anna and she can ask questions about, for example, why we need it as a precursor to your questions and discussion. Thanks, Anna.
No, I just wanted to ask, because I know we have the Human Rights Bill, we have in particular, very particular topics, we have rights for people with disability, we have rights for, so why exactly do we need a bill that covers rights for women specifically? And what areas does it cover the proposed bill? Is it mainly about work? Is it about more stuff? I would just like people to know more about what is composed of and why do we need this bill.
Right. The CEDAW has a considerable number of provisions. They relate to public life and they relate to private life. Now, many people say, well, what's the point of having a law? Because it doesn't help us at all. And yet it's really important to have a standard that says these are women's rights, because first of all, about that, unless our rights, in my opinion, are written down clearly where we can see what they are, and we can argue for them because they're there in writing and the government can't say, no, you don't have that right. If the rights are all up there in the sky somewhere and they say, look, it's all right, they're all up there and rights are protected, that's no good, because that fits into, I'm afraid, what is the class system here. It fits into the notion that those who are powerful can say what the rights are. We need them written down. And if there's something written there that we don't agree with, we can argue. We can say that's no good. We need it improved, or why isn't this there, etc. And the other part of it is that, take, for example, rape in marriage. Now, for a very long time, because Chief Justice Hale said back in 1640, and it was published in 1736 in his Pleas of the Crown, that rape in marriage wasn't a crime. For centuries after that, everybody, well, when I say everybody, the people in power said that there's no such thing as rape in marriage. And then in 1888, there was a case, the Crown and Clarence, that has always been used as authority supporting Hale when it says nothing of the sort. And it took until 1991 in this country for the then House of Lords to say that rape in marriage was a crime. Now, we need that to be stated very clearly. And of course, it's not going to stop rape in marriage. I mean, one's not living in a dream world. But once it's written down, then we know that is a crime. And if a man rapes the woman to whom he's married, then that will be considered to be a crime, just as much as if he raped some stranger on the street. And we need it, therefore, to say, that's why we need a Women's Bill of Rights. We need to set out clearly what our rights are. And those who are depriving us of our rights need to know that we know that that's what they're doing. And then, I mean, that's the first step. You get the rights written down, and then you have to work to get the rights implemented. But the first step is actually writing it down. And there's not all the provisions in CEDAW with the updates of CEDAW through the committee in our law at the present time.
Sorry, I just mute myself because there is some noise in the background as well. So I would like to ask now, what can we do as individuals, or what can we do as a group? What people in the public can do to help this bill pass, or to promote this bill, to get the word out there?
There's 3 petitions relating to this, and I'm just putting them up on the screen, the links. And then there are a number of Facebook pages that you might want to link up to. There's the CEDAW People's Tribunal. This sat in June last year for 3 days, 21 through to 23, and heard evidence from women around the United Kingdom, women in practice, women in research institutes, women in academia, and women who are working on the grassroots. And they spoke about all the ways in which the laws in this country and women's position is undermined, is not affirmed, the way that there are inadequate services, the way that we need to ensure, for example, that women have equal pay. We don't yet, it doesn't matter what field it is, don't be led astray by any notion that there's equal pay anywhere for women. There simply is not. And so the CEDAW committee and the CEDAW People's Tribunal, and then we've got CEDAW in law, And on the 13th of July, CEDAW in law ran a tribunal on the issue of the women's state pension rights, because I'm not sure if there's anybody on the call who was born in 1950, you've been robbed of your state pension rights, because in 1995, under the State Pension Act, the determination was made that the retirement age of 60 at which women got the state pension would be raised over time to 65, which was the age at which men got the state pension. And I have to tell you, George Osborne, who was the treasurer at the time and manufactured this change, actually gave a speech in New York where he said that he'd effected this change and saved billions of pounds, and that the women were so foolish that they wouldn't realise what had happened, etc. Now, these women from the 1950s are obviously women who were active and in the 1970s in the women's movement. So, of course, they're not going to be quiet about what's happened. And this CEDAW in Law Tribunal heard evidence from women about that issue. And that Facebook group is agitating on that issue in particular. And then Back to 60 is also a Facebook page that's concerned about this issue of the pensions, because the whole issue of pensions goes to women's economic rights, which are recognised and acknowledged in CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women. So I suggest that those who are interested and concerned about this issue go to the petitions and see their wording and sign up if you believe that you wish to put your signature there, and go to the Facebook pages to see if the issues that are being raised in the CEDAW People's Tribunal Facebook page, the CEDAW in Law People's Facebook page, and the Back to 60 are issues that you can get engaged with and organise in this struggle to have the Women's Bill of Rights implemented. And then the other point I'll make is that on the 8th of March this year, we had a Women's Parliament in the Guildhall Council Chamber here in Cambridge. Anna was one of the speakers, and we spoke to a motion for a Women's Bill of Rights. And we're going to do that again on the 8th of December. I think it's a Thursday. And then that'll be another Women's Parliament. And on the 8th of March next year, we'll have another Women's Parliament. The one in December will be focusing on violence against women in all its forms. And then the one on International Women's Day next year will have another Women's Parliament focusing on the need for a Women's Bill of Rights.
It was an amazing experience actually to go there and see all full of women and from very different backgrounds and speaking about so many issues. It was really empowering. So some people is asking if we can share these links, because they can actually not click on them. So just will you be able to send me these links after the session so we can share them with everyone?
Yep.
And someone is asking if the slides could be shared after the session. I don't know if you'll be happy to do that. Just you can answer me later on and I will tell them on the email. And I think, should we kind of move on to the Domestic Abuse Act? Because that's something quite new that came out last year, and it was a bit mixed emotions because there were a few things to celebrate from it and a few things that kind of let us down. And so can we, oh yeah, I like this thing of the definition of the domestic abuse and the implications of this wording. Are you going to speak about the language, Jess, of domestic abuse and domestic violence?
Yeah, I know that there are mixed views about this, but I have to tell you, the use of the term domestic abuse, I find not particularly helpful. It seems to me that it's anodyne, that it blandizes, if I can make up a word, what really is violence against women. Now, what's being said is, oh, well, every act of so-called domestic abuse is not violent, and therefore we need to have this overarching term. But then I would ask, right, is marital murder domestic abuse? Is grievous bodily harm domestic abuse? Is a woman being stabbed by her partner is that for former partner, is that domestic abuse? You see, what we've done in this term domestic abuse is lowered everything to the lowest common denominator. That's number one. And number two, I can't abide by the use of this other term, DV. What is DV? Spell it out. If you want to say DV, say domestic violence. And FGM, don't say FGM, say female genital mutilation. We have to actually use language in a way that speaks for us and that speaks to what the reality is. And domestic abuse, as I say, it just sounds to me so bland and it trips off everybody's tongue. I've been to conferences and they're talking about domestic abuse, and they don't actually bring home the reality of women who suffer what is violence. It is violence. Now, you see, look at this. Physical or sexual abuse. Well, physical or sexual abuse to me is violence, frankly. Violent or threatening behaviour, well, that's violent. Controlling or coercive behaviour, that's violence in another sort of way. It's violence that's being affected. It's like as if you know, when you get a dish rag and you wring it out like that. That's the sort of violence I see in controlling or coercive behaviour. Economic abuse, that is violent. If, for example, there's a debit card and the man goes down the account every time and says, oh, you know, what's this money spent on? And the woman spent it on, oh, I don't know, you know, tampons or something, and there's a great big hoo-ha and fuss about that. Or say that she's actually taken herself to the hairdresser to have a hair wash. Oh, well, what's this happening here? You see, in my opinion, women experience this conduct as violence against them. And to call it domestic abuse, well, I don't like it. I think we need to name really clearly what it is that's going on here. Psychological, emotional, or other abuse, well, I think that psychological is violence.
I think just there is like a comparison that I have very often in politics, and I brought that to the training of the Ask Me sometimes. When we speak about the term of domestic abuse and domestic violence, we explain the people do not identify psychological threatening or these definitions under violence because people has the image and the perception the violence is only physical. Well, and that's what the discrepancy that we may have with the decision making in the government is that rather than educating people and saying there are other forms of violence and they still being violent, they opted for changing the language and use a word that may encapsulate more types of violence by the perception of people. For me, like you, I find it an error, because if you extrapolate it to a country, like when we speak about protests in Paris and people see the people are putting fires in the road and they call that, oh, people are being very violent in Paris, but they don't see a government, maybe during the French Revolution, for example, they were starving people. They knew that intentionally they were starving people so that the elite could have more grain and cereal. That is also a form of violence. You are starving children. You are starving the people with intention. This is a form of violence. But because it's not that visual and it's so abstract, it's very difficult to identify it as violence. Psychological abuse, it is violence, but people don't identify it with it. So do we take the route to educate about this, or do we take the route to choose a different term? And I guess that there is the debate is trying to, what do we do? Like now, for example, people probably are more aware about psychological abuse because they realize that actually is put at the same level as the physical one. And that means that more people are reporting it. So there is a positive side on it, but how do we make sure that actually people gives the significance that has, because it's still violence, it's still very significant.
Well, you see,
yes.
with some irony, the courts have actually recognised some acts that in the community, they might not see them as assault. I mean, in the common law, if I raise my fist, that's an assault. And if I hit somebody, that's a battery. But the law didn't ever recognise words as an assault, and now they do. For example, there's a case where, Constanza, where what happened was that the man sent the woman numerous letters. It was before emails, it would have been emails otherwise, numerous letters. And then he stood outside the house, just standing there. That was recognised as assault in the criminal law. See, I talk about criminal assault at home and other forms of domestic violence because we need to get home that this is criminal. And another example, if somebody rings up on the phone and says horrible things, if they breeze down the phone, if they maintain silence, that's all recognised in law as an assault. There's cases on it. So we've now got, ironically, the courts actually recognising that these acts or this conduct is assault and it is criminal. People have been convicted of it. So therefore, I don't know why we are pandering to this idea of domestic abuse and that we parrot it constantly, because why don't we take control and why don't we say, this is the language we want to use, instead of you having this language imposed on us because old people say that they don't realise that psychological violence is violence. So see, I just think we have to lead with the language, because language is really powerful. And Glanville Williams, who in my opinion, had some problems in terms of criminal law. But one sensible thing he did say is that language is powerful, and the language of the law is the most powerful language of all, and it is powerful. And if we can ensure that the language that really describes the reality of women is the language that's incorporated into the law, that's an achievement, in my opinion.
We are at the stage where with the outreach team supports women who are in a domestic abuse relationship or just left, or they are seeking support because of it. And we are still at the stage where some housing officers, even though this law says that because of if you're fleeing domestic abuse, you have preference when looking for social housing, which is something to celebrate. We are at the stage where the officers are not identifying that someone is fleeing domestic abuse, or because you've not been beaten up, you are not at risk, so we are not giving you Band A. We hear that a few times. And it's like this person is fleeing domestic abuse, is in a refuge. This person needs housing and needs a housing soon, and they still not understanding what means domestic abuse. It's not only physical violence. It's not the fact that you've been beaten up or no. It's something way more forward than that. And it's so difficult. We want to change the language again and again and again, when actually people are not even understanding the concept. So it will be interesting to speak about how we go forward with that, because it's something that is coming up again and again, and we haven't found so far a way to make peace with it and to make like one rule that helps everyone and that gets understood and that goes through and that works. So yeah, it's quite difficult. It's a difficult one. But yeah, Jazz, is for you anything good to celebrate from this bill, from this act?
Yeah, I'm just trying to get it back again because I don't know what happened then. Yeah, there are some really good things. Now, it's actually really interesting and really powerful. Where are we? Yeah,
Domestic Abuse Act.
Yeah. Now, what's interesting about it is, this is just about personally connected and so forth. I just put this this definition here.
No, but this one is also very important, because within the care sector, when you see people who are the carers of someone with a disability or an elder person, and it's maybe the son or the daughter or is a cousin or is a nephew, but when they report to social services for many years, it is not been reported as domestic abuse because they were not partners. And even so personally connected, and that there is a significant connection. You either live together or that basically they have power over you, as simple as that. And is it that difficult to realize that? But in the social sector was not being identified because there was not this definition of personally connected. So that's, I think that's a significant advance for some minority groups who were actually very left aside.
It is though limited because it's limited to these particular relationships. I mean, you know, and there is dispute about all this, isn't there? Because there's a dispute as to whether within this concept we should include just all relationships, or because you see, say siblings, I suppose relatives, siblings will fit into relatives, and there are instances, as we would know, where siblings can be violent. I mean, we've got boys who rape their sisters, etc., and I'm sure that there may be some girls sometimes who are violent. We don't ignore that, but the reality is that it's mainly, I'm afraid, violence by men against women. And so that would come within relatives. But you see, some people think that if we incorporate everything under this notion of domestic, then we're undermining the violence that takes place within intimate relationships. On the other hand, there's, yes, the point that you're making, Anna, that if somebody's a carer, then why is that? I mean, that would be addressed in the law, but it wouldn't be addressed in this law. So there is that issue of personal connection of what it means. And then there's the definition of a parental relationship. Now, this is something that's very interesting because I don't think I've put it down here, but if somebody is going for one of these orders, they're calling them now domestic abuse protection orders, and they're incorporating all the orders, you know, non-molestation, etc., under that heading now. But one of the matters that the court must take into account if such an order is to be issued is the issue of a parental responsibility for a child. Now, all our antennae should be up, because what we know is that that can be used by judges or justices who are stereotypically and traditionally orientated into thinking that a child should not be brought up in a relationship without two parents. You know, male and female generally is the way that these traditionalists think. And so therefore, if there is a child under 18, the big risk for women is going to be that the order will be perhaps not issued because of the father's relationship with the child. Whereas, of course, you can think of it from the other point of view, which is that if there's violence against the woman, it's violence against the child, and that is now recognised. And so therefore, that really, the fact that there's a child to whom the man has a responsibility shouldn't be used as a reason for not advancing an order. Although, you see, I've got problems with those orders in any event. If I can just interpose here before coming to this, which is some positive elements. Somebody who works in the field told me that in a particular division of the police in London, they don't have enough resources to police all the orders that are being granted. That's number one. And what I will say to you is pay attention the next time a woman's murdered, ends up unlawfully killed, because so often there is one of these orders and they don't actually stop people from killing, men from killing. And the other point about these orders with which I take issue is that you're not going to get an order unless there have been a number of criminal offences committed against the woman. Because it's not going to get an order just when there's a one example. I mean, maybe somewhere in the country that will happen, but it's not usually what happens. There's a series of criminal acts against the woman, and then she gets this order. And then if that order is breached, it's not because she has actually had another crime committed against her. It's because it's an insult to the court, because it's a breach of the order and it's a contempt of the order. So what's happening is, first of all, you have a number of crimes committed against you, and instead of them being dealt with through the criminal justice process, and I know some people say, well, women don't want to go through it, but that's another issue we need to deal with. But so these crimes are committed against her, no criminal action taken, an order is issued if it is, and then if that order is breached, it's not being the penalty that's following is not because a woman's being beaten up again or a crime's being committed against her. It's because there's contempt of court because the order of a court has been breached. And I think we need to address that. But anyway, let's come to really good things. Controlling or coercive behaviour, well, that's already been in the law, in the Serious Offences Act, but they've redefined it to a certain extent. Disclosure.
I wanted to say with this one, at least in Cambridge Women's Aid, we celebrate it very much until we realize how difficult it is to evidence this. Now, it is really good, it's a start that it became a criminal offense, which is good, but to evidence this is so complicated that how is ever going to be used? It's so difficult to use, and that's actually what is the center of domestic violence is the coercive control. Is what is at the center. In many cases, there is no physical violence. In many cases, there is nothing that you can evidence with in terms of finance. Or you don't have witnesses that have seen any episode or any comment, and how do you evidence this? It's so complicated, but it is to celebrate, because it is a start to say, okay, now it is a criminal offense, let's develop this. So I think that's something that people should keep working on this and how to evolve with this part of the art.
Yes, I think that's let me see, I don't want to get rid of it. Yes, I think that's an issue, but at least, as you say, it's actually articulated in the law and it's recognised to that extent. So it's the first step. Now, this issue about disclosure of private sexual photographs and films, there's a flaw in this because there's some good things, threats to disclose private sexual photographs. So the prosecution doesn't have to prove that the photograph actually exists or the film exists. It's enough that there's this threat to disclose. So that's actually good. But the drawback is with intent to cause distress. And so it's not enough that it's actually explicitly written in that it's not enough that we could assume or infer that the release of whatever it is that's being threatened would cause distress if the prosecution proved that the person who made the threat was intended to cause distress, then it won't, the crime won't be proven beyond a reasonable doubt. Now, that just seems to me to be ridiculous. And that's how the law is at the moment. They've just actually jollied it up a bit. But the point is that, look, if somebody threatens you and says, look, I'm going to release these naked pictures of you that I took unbeknownst to you or unbeknownst to you when we were in an intimate relationship, but what the hell are they saying that for? Clearly they're saying that to cause distress. And why should the prosecution have to prove it? It should be res ipsa loquitur. The facts speak for themselves. But no, this idiocy, in my opinion, and I have to actually speak really firmly about this, is still incorporated in this. And when we had the CEDAW People's Tribunal back in June last year, there were really good women who've been working on this field of, technological and internet invasions and violence. They're in Scotland, and there's a lot of work that they've done. They're really exceptional. And I wrote all this up in my report from the tribunal, and I've written about this issue. And it needs to be, that's an area where we need to actually pay more attention. Well, actually, the people who wrote up this bill, this act, need to pay more attention. But then we come to offences against the person and the strangulation or suffocation. This is where there's actually a miracle has happened. Back in 1977, last century, myself and a couple of colleagues, this is in Australia, we did the well draft bill on sexual rape and other sexual offences, women's electoral lobby, this was. And in that, what I wanted was that if sexual intercourse takes place and there's violence associated with it that inflicts grievous bodily harm or grievous psychological harm, then consent is irrelevant. And that fits in with the law generally, because in the law, there have been a number of cases, Brown's the principal one, where what's been said is that if grievous bodily harm, serious bodily harm, and in that Brown case, it was actual bodily harm as well, though there were a couple of judges that dissented from that. But if grievous bodily harm occurs, then consent is irrelevant. I mean, you must know, you will know that if you have an operation, say your appendix is taken out, well, the doctor's doing grievous bodily harm. And the only reason that it's legal is because it's for the woman, sorry, for the individual's health. It's no good if you've got a suppurating or a bursting appendix inside you. That's not good for your health. So for your health, it will be removed. And the second reason that it's legal is because the patient's consented, or if they're, you know, unconscious, somebody can consent for them, or if it's urgent, then there's something, an urgent court can be called into action, etc. So in rape, where there is grievous bodily harm caused or grievous psychological harm, what we wanted in the 1977 World Draft Bill was that consent would be irrelevant. And that's actually written in. See, offences against the person is Section 71, consent to serious harm for sexual gratification is not a defence. And this is covering the cases, you know, where the latest thing is that they say, the latest thing is that they say that, it's not me, I don't know who it is, but the latest thing is that the guy will say, oh, well, you know, we were having consensual sexual intercourse and she was turned on because I was strangling her, etc., etc., and I'll look terribly sorry, but it just went over the edge. Well, that would not actually be a defence anymore if you end up dead as a consequence of being strangled by some fellow who says that that was your sexual thrill that you were looking for by being strangled. So that's actually a really positive thing. And of course, the fact that strangulation or suffocation is an offence against the person, because there have been too many cases where this has been brought up as the defence in instances where it really ought not to be. So that's...
There is another point to make in terms of this kind of assault, strangulation and suffocation is extremely personal, and we know it's a big red flag when it comes to assessing risk. We know that this is a red flag that means that there is a high risk to lose the life. So that if you get to the point of strangulation, it means we really need to act quick, because it's as I said, it's just a big red flag. It's just a sign of we need to move. So probably that's been highlighted in so much research that it's been taken in consideration within this act. Like it is a big one, even so more than what can be any other kind of physical assault or even sexual assault. This one is particularly taken in consideration when assessing risk.
I think it is important, because you see, what keeps happening is that excuses are invented that are then put forward as defences, because it's something about, well, I suppose it's about the law, and it's about barristers exist to defend their clients. Now, some of them, I mean, there's a really good book, you know, that people might like to read, and it's called Witness by Louise Mulligan. She's actually a lawyer, but she's a journalist as well. And it is actually really very powerful, this book about the place of witnesses in cases of it's mainly about sexual abuse against children that she's giving examples of, because she was involved in writing another book about an archbishop who allegedly sexually abused children in relation in the church. But it is a really interesting issue that somehow, you see, I'm coming to the point. What happens is that someone argues this. The guy says, oh, look, you know, she was wanting me to strangle her and I'm terribly sorry, but it just went over the edge. And then that idea comes into the legal knowledge and it seeps into the court and it seeps into the knowledge out there. And so therefore, when some woman ends up dead, then the argument is, oh, well, she consented to being strangled, because you see, we're all going on to the internet, allegedly, and looking at pornography, allegedly, and therefore, you see, we're all getting this thrill by being strangled when we're having sexual relations, which doesn't really, in my opinion, make terribly much sense. But this has got us on to rape law, because if I can just actually talk about, separate from domestic abuse, but about the rape law, because this does fit in with the strangulation or suffocation. What's really interesting is that we went through a period, this was the 70s and 80s, where we realised that consent had to be defined really clearly as to what consent was not. And that was a really important move. And if you look at the Sexual Offences Act in this country of 2003, they have a definition of what's consent or what isn't consent, and that you can't argue the woman consented when she's unconscious, when she's asleep, if you put drink or alcohol or drugs in her drink, if you kidnap her, etc. And that was not clear in the common law. If you kidnapped a woman and sexually raped her, there'd have to be a whole new proof that you'd actually raped her, instead of saying, well, if you kidnapped, it's hardly likely that you're going to consent to your kidnapper. And if you do go along with it, it's your life, or it's because you've got into the Stockholm Syndrome situation, which is not a real consent. Anyway, that's all defined now in the law. But the problem with it is that it's now directed attention on what's going on in the woman's brain, instead of the focus being on the accused person, which is where the focus should be. So I'm not renouncing having defined consent. In my opinion, it was an important step, but we've got to go beyond somehow to work out how we get into away from this idea that it's all about the woman and into the reality of it's about the accused person. That's number one. Now, number two, because of the sexual history evidence issue, you know that she's had sex with him before, so therefore she must be consenting this time, or she's had consent with other men and therefore she must be consenting to him. That's the argument. The argument is the one that was used in the Evans case, that footballer. But what was done to address this issue was that there's a provision now in the law that says, that relies on similar fact evidence. That is, if the sexual encounter that she had with a person or with other persons is of the same factual matrix as this factual matrix that's coming or happened in the case that the alleged rape, then that will be allowed into evidence to show that she did it that way in the past. And so if it's happening this way now, that will show that she's likely to be consenting now because she consented that way in the past. Now, let me give you an example, apart from the Evans case, where this was used, this provision. The man had allegedly raped the woman with her on the monkey bars in some playground somewhere. And what was put into evidence, a similar fact, was that sometime before she had allegedly consented to sexual intercourse with her spread-eagled on those monkey bars. Now you think about it, you know what I think? There's somewhere in the pornography field on the internet where there are women in pornographic depiction, exploitation of women, where they're allegedly consenting to being to sexual intercourse, spread eagled on some sort of contraption. And the interesting thing about this is that there's another book called Eggshell Skull by a woman called Bree, it'll come to me. She talks about, she was associate to a judge, and she talks about a case that came up before her, where this was an Australian case in Queensland, was a young child, actually, young person, was sexually abused from a washing line. In Australia, they have a washing line, it's a Hills hoist, and it's on a pole, and it's like a tent. It's got spines coming out. And so somehow this sexual intercourse took place there. And I think it's a pornographic episode that takes place in film, and then are picking it up from that. But to come back to this, you see, similar fact evidence is what's allowed in for accused person. Say, and I'll end on this note just really quickly, the famous case is the Brides in the Bath case. This was Smith, the Crown and Smith. And Mr. Smith used to link up with some single woman who had no family or anything. He'd get married to her, he'd put, unbeknownst to her, insurance policy on her, and then he'd busily take her to the seaside somewhere, and then lo and behold, she'd be found drowned in the bath. What was happening was he was doing a bath with soap suds, isn't he lovely, etc. And then he'd come to the end of the bath and yank her feet, and so of course she gets drowned. Well, Mr. Smith did this on a number of occasions, same scenario, linking up with some woman who had no relationships, no friends, etc., marries her, insurance policy, takes her to the seaside, different seaside every time, of course, he wasn't completely stupid, and does the bath, then yank, and she's dead. Well, they caught up with him, and they were allowed to put that evidence in as as similar fact evidence to show that this was the sort of conduct in which he was engaging. So come back to the woman who is the principal witness in a rape case, or they want to call her the complainant. What they're doing by having that similar fact rule about the sexual history evidence is they're turning the victim or the alleged victim and survivor into the same sort of category as an accused person. And women who are the principal witnesses, the complainants so-called, in rape cases, are too often put into that sort of category in any event. And what the law has done, I'm sure that the rationale behind it was a positive one, but it's not in the end. We need to look at that.
I will say there is a clear example for that, and that's the first thing that came to my mind when I saw this. And it's gonna sound weird that I thought about this, but lately I've been exploring the porn environment for term of education purposes and what's going on there, and I saw lots of it. So basically, you consider someone who is into BDSM, and you say, okay, they do consent into body harm, they do consent into intentional body harm. But what about if someone, like you said, creates a relationship with someone, they are into this world, and then eventually one day she says, no, I don't want anymore, or she basically one day she doesn't consent. That means her previous attitude, behavior, and history will be taken in account to say, well, you had this before, so why are you complaining now? And like you say, the victim will become the one that is being judged based on what she's been doing before. It is quite massive nowadays. I was checking in terms of where children are learning porn nowadays, and it's so different from the 70s, 80s, and the Playboy house. It is quite brutal, but there are some people who enjoys that, and like, we are not going to be judgmental as soon as it's consented and they want to do it. But what about if that's actually used afterwards to defend themselves from what you are saying, like, oh, this person was already in this world, so probably she was consenting into it.
Well, the funny thing is, you see, that's why consent to serious harm for sexual gratification is not a defence. And so anybody who's engaging in that sort of conduct, they are running the risk of a claim of an offence against the person. But it is, you see, the idea is, the original idea was that if you had sex with somebody consensually as a woman, then you more or less were, it was a free for all. The idea was that you had no discretion or discrimination about who you were going to have sex with. The idea that, and so this sort of idea has permeated the law, and that's why what they call rape shield statutes were brought in to try to address the problem of the assumption that a woman has said yes to this one, so therefore she's saying yes to the 100 footballers, or she said yes to this man, so therefore she's saying yes to him, at any time of the day or night. And it just doesn't make sense. I mean, that's not how, well, my experience, my knowledge, I suppose, of other women, you don't just have sex at any old tick of the clock. I mean, it doesn't make sense. But you see, that's this ideology.
I was going to ask you, just because we are kind of running out of time now, and I wanted to ask the last one within the domestic abuse. Many people were let down because of a migrant woman. They were completely left out of they were asking for certain rights, and they've not been tackled within this domestic abuse act. I don't know if you would like to say a bit more about the fact that they still don't have the same rights of someone who's got British nationality, or what the issue is when they go to a refuge and so on.
Asylum seekers and refugees, women in that category. There was a lot of evidence given in the CEDAW tribunal last year about this issue, and it does need to be addressed. There's no question about that, because being a victim of a crime shouldn't be hanging in any way on what your actual status is. And the difficulty is, of course, that the threat is used by men who are violent against women, that they'll be deported, etc., if they actually complain. And what's interesting is that, if I can just say something about trafficking, because that's actually quite interesting, that in the Trafficking Act of 2015, there is a provision, I think it's section 45, that says that if you are forced into committing criminal acts because you're a trafficked person, then that can be a defence against the criminal act. But you see, there are a lot of crimes that are exempted from that. I mean, there's more crimes exempted from it than possibilities. And there's a case going on in the States at the moment where the woman, I think, is about 18, and maybe in Wisconsin, and they're saying that she can use as a defence the fact that she was a trafficked person and whom she killed was the trafficker, because in the law here, under the Modern Slavery Act of 2015, it explicitly exempts murder or unlawful killing from the possibility that there can be a defence to it because you were a trafficked person. So the whole area needs to be looked at. And the other aspect of it is that if somebody's been trafficked, there's no deporting them. And then you've missed your principal witness against the traffickers. If we're going to do something about trafficking, we have to retain the witnesses here, the persons who have been trafficked, and not say, right, well, we'll deport them because there's some invalidity with their visa, etc. And I think the point you've made, Anna, of course that's right, that laws that relate any form of criminal activity shouldn't be based on whether you're a citizen or a resident or a refugee or an asylum seeker. But one thing about the asylum seeking, which is a positive thing, is that the law does now recognise that if your argument is that you have a well-founded fear that if you're returned to the country of origin, you'll be brutalised by an ex-husband or a husband or ex-partner, etc., then that is a ground for being retained in this country. It's accepted as valid. That was first accepted in Canada. Canada's been quite good about that. And therefore, there are some positive developments in terms of refugee and asylum seeker status. You're on mute, Anna.
Sorry. I just wanted to, well, just to make a comment, because Marion is asking here something about whether someone who is in BDSM is interesting because the purpose is to stop the other person from being angry. And for what I was exploring during this time with porno as well and so on, like speaking with people as well. No, they don't look about making the other one happy. It is quite a selfish environment. They go there for their own happiness, independently which role they are playing. And to be honest, I've spoken with men and women, both were doms and subs, and both they don't identify being sub or dom with the gender. It was more like I'm a sub, maybe it was a man and the dom was the woman. So I don't actually, what we see from the outside world is very patriarchy dominating issue. And actually when you kind of speak with people, you see that that's not the case. Still, I stopped finding it interesting. I just cannot understand it because I am not this kind of person and I cannot understand it anymore further. But I kind of challenged myself in understanding what the roles were and what actually they were looking for. But yeah, it was just to answer this. Now I just wanted to ask if anyone has any question for Jazz. And we barely have like 10 minutes to finish and give a few tips about events that are coming on after this. So if anyone has any question, if Marion has got a question, Jazz, will you mind stop sharing now? And so we can, yeah, that's perfect.
Sorry.
Thank you very much.
Oh, no, it's new share now. What's it doing? Sorry. Stop share. Sorry.
That's okay. That's perfect. Don't worry.
Sorry.
So Mariam, would you like to unmute yourself and ask any question you have?
Yeah, thank you. That was really, really interesting. And it's good to hear that there are more acts in place. And if you get to court, you've got a better chance of being heard. What worries me is that the chances of getting to court don't seem to be improving at all. Both the police and the CPS seem to have a reluctance, shall I put it like that, to start the case off and to take it to prosecution. And I wonder what, if anything, can be done about that. You're on mute.
That's it. It's really important you raise that, because I've just been looking at the Crown Prosecution Service statistics, and what's interesting is that, of course, they've got resource issues, everybody does, but the 3 crimes that they drop the most often are flashing, criminal assault at home and other forms of domestic violence, and rape. And you really have to say, why are they doing that when all those crimes are primarily against women? And I'll come to what you've asked, but I just do want to say something about flashing, because with flashing, there's this idea, oh, well, it's not particularly important, it's trivial. Now, I would guarantee there's nobody on this call who has never been flashed at. Absolutely no one, because all women, doesn't matter whether you're a child or you're an adult or whatever, somebody has flashed at you. And the thing about it is that we all don't sit down in the middle of the street and sob, or, you know, go rushing off in a traumatic turmoil. But the point is, I'll come back one step and say what they want to say is that it just sticks at flashing and it doesn't lead to anything else. Well, it does, because those who engage in flashing or in being peeping toms, they do, generally speaking, go on to commit other sorts of crimes. But even if they didn't, it isn't fair that we can't live in a world where we can walk down the street or go to the beach or something without having some fellow flash at us. To give you a quick example, I was flashed once. This is like going into my chambers in Melbourne. I'm walking on a Sunday up Little Bourke Street, and there on the steps of the Federal Court is this fellow masturbating deliberately in front of me. Well, what do? Of course, I just walk past, ignoring it, because you think, you know, where am I? What am I doing? And so forth. And also, you are really a bit frightened because you never know what's going to happen next. But what I'm saying is that this idea that flashing isn't important is in and of itself wrong. But and anyway, it leads to other activity. But the thing about, I think we just have to keep on at those in authority and saying that these acts have to be taken seriously, and that I know that that's an inadequate answer. Or I did want to say something about legal aid, because what the Domestic Abuse Act says in the guidance and so on, it says that legal aid will be available for these non-molestation orders, or what they're calling them now, domestic abuse protection orders. Legal aid will be available for those. So at least that's, I suppose, a blessing. But there needs to be training too. I know that education isn't the answer to everything, but one of the provisions in the World Draft Bill from back in 1977 was that when you bring in a change to the law like that, you have to actually educate the judges and the magistrates and the barristers and the police, because, and they've actually adopted that now in Canada. Last year, they brought in their rape changes that it's mandatory that everybody that's going to work in that field has to have education. Because you think about it, we've got the Sexual Offences Act of 2003. Now, when that came in 2003, who were the judges? Who were the barristers? They'd never done the Sexual Offences Act 2003 at law school, because when they were at law school, it was the Sexual Offences Act, I don't know, 1957 or something. So they've never had any training in it. And when people go to court, one of the problems is too that they actually don't know anything about the Convention on the Elimination of All Forms of Discrimination Against Women, or many of them don't. I doubt that I would say very few, if any, and that came up in the CEDAW Tribunal as well. So we need to get compulsory education. They have to be compulsory educated. And if the judges say, oh, we don't need it, I'm afraid we just have to say, well, you do. And the barristers need it, because let me give you an example. In the most recent CEDAW Tribunal that we had on the 13th of July, one of the women said that when she went to court for her divorce, the judge took into account the fact that she was going to qualify for the state pension when she turned 60. Now, she wasn't, because the law, she was born in the 50s, and the law that came in 1995 impacted on her. So she wasn't getting the state pension at 60, but the judge took into account something that was not reality. It wasn't a fact. Her barrister didn't raise it. The other side didn't raise it. She didn't know. And so therefore, you've got this massive change, and nobody in the courtroom knows that the massive change has taken place. And this woman's rights are impacted by the fact that there's ignorance in the court. So that's really, I know that's inadequate, but I just think that that's one of the issues that we should be pushing for. And in our Women's Bill of Rights, we're going to have a provision in there that when the Women's Bill of Rights comes in, that all the judges have to be educated in it. And we need to get the Law Society, the one that trains that has the control over the solicitors, and the one that has the control over the bar. They have to make sure that their cohort is educated too.
Yes, I'm just gonna say a couple of things, and after that, if someone wants to ask any question, we'll be here. But just in case someone wants to go, I just pasted a survey form for feedback. If you want to leave any feedback, we will be very grateful. I would like to remind you that on the 5th of August, we have the first library session in the Central Library in Cambridge. We are going to speak with the public about domestic abuse, and it's going to be based on the book What Kind of Girl the first 2 chapters, and we will read them there as well. So they are very short, and we will be speaking with everyone about what happens when someone discloses. And then we also have the well-being sessions on Wednesdays that have been organized by the council, and there are going to be many organizations, and we're going to be there. And then I think just had a couple of events to highlight that are quite good actually, with regards to recent events from the US Supreme Court decision. I think when is in August?
Yeah, on the 12th of August at 5:30 p.m. it's a Teams webinar. There will be Dr. Sarah Sargent, who's from the United States, but she teaches at the University of Buckingham. There'll be Professor Elisa Organic, who is from the University of New Mexico, and she's a Native American. There'll be Camilla Wagner, who is from Sweden, and I'm in this too. We're going to discuss Roe and Wade and Dobson Jackson and the impact in the US, but the impact that it may have globally. And we're each going to speak from a different perspective for 10 minutes and then have it open to discussion. Unfortunately, I haven't got the link here at the moment, but I'll send the link to Anna so that she can distribute it, because the whole issue of abortion is really important here. Women just think abortion's legal and don't realise that in this country there are still conditions under which abortion in this country is criminal. And there's a provision in the Abortion Act itself, and then the requirements under the Abortion Act are sex discriminatory. What other medical operation does one by law have to get 2 doctors involved in it to say, you know, that you need this abortion? What other medical operation has a requirement that the doctor has to send a report that you've had an abortion down to the chief medical officer of England, if it's here, or the chief medical officer of Wales? It's this great big long document. You can see, if you go to the Abortion Act, you can see it. And ironically, the Offences Against the Person Act of 1861, the provisions on abortion, have been repealed for Northern Ireland. So abortion is not a crime in Northern Ireland anymore, but it remains so in this country, Wales and Scotland. So we're living in this sort of dissonance of thinking that everything's okay with abortion in this country, but it's not. And we need to be aware of the limitations. But anyway, that's on the 12th of August at 5:30 p.m. I think you're on mute.
I wanted to share that during the 16 days of action or domestic violence in between, I think it starts in the 25th of November until the 9th of December. We had an idea with Jazz, which I don't know how many of you are going to like this, but I think many of you will know Kate Bush and Wuthering Heights song. So it became a kind of fashion to do a dance in the street, wearing all red. I'm just going to share the screen so you can see the picture. I'm not going to share the dance now, but just a picture for you to have an idea. So they just gather together and do a very funny dance, and with the song Wuthering Heights, which is really empowering and motivating. And we thought to do this dance all wearing in red in December for against domestic violence or any violence against a woman, to be honest. And we would like as many people as possible to join us. So I will keep you updated when we start to get ready for this. But I think it's something beautiful to do. If you see it with the song, it's really like, I want to do it. So I hope
Can I just say, because it's really wonderful. You should go on to Google and watch it. And when Kate Bush sings Wuthering Heights, she sings it when she's in white, but she sings it when she's in red. And with the black.
To learn and recreate the iconic dance routine from her 1970s
Can you hear it?
song, Wuthering Heights.
Yeah.
The event is raising money to support women, children, and pets in domestic violence refuges. Dance organizer Rebel Lyons says it's all about fans honouring Kate Bush in their most eccentric style.
Isn't it wonderful?
Yes,
Yeah,
it's very,
it
you
is.
look around, you won't see anyone feeling. It's not about getting the most.
Yeah, I couldn't find right now quickly the video with the dance and the music, because it's amazing when you watch it. But yeah, this is the idea. We would like to do that in December, and I would like to invite everyone to come in and join us, because it's going to be fun. And yeah, just to remind you, if you haven't done so, please join the Ask Me training. It's for free, and it helps you to understand how to respond in a better way to domestic abuse disclosure if someone tells you, where to signpost them, and how to challenge myths and stereotypes that keep damaging the image of domestic violence in the community. Is there any other event just that you would like to share, or?
Oh, just that we'll be having the Women's Parliament again on the 8th of December, because the 10th of December is International Human Rights Day, but that's a Saturday. So I've already booked it, the 8th, for the council chamber. So if anybody's interested, get in touch with me. It's going to be that you have to have a speech of 5 to 6 minutes maximum, so that we can get as many women speaking as possible on any aspect of criminal assault at home or other forms of domestic violence or rape or sexual assault, etc. And then on the 8th of March next year, we'll have another one, and I've got to think about the actual theme, but it'll be again on the basis of a Bill of Rights, a Women's Bill of Rights, to promote that. Yep. Oh, I know, and I've got my Brilliant and Bold. Every second Sunday of the month, I do Brilliant and Bold, and it's international. I get women from all around the world at 11 a.m. on a Sunday. It used to be in the House of Lords. I used to have it in the House of Lords, but when the House of COVID came along, I put it online. And with the House of Lords, having somebody international depended on somebody being in London at the time. And so now I get 4 women from around the world, often somebody from Canada or the States, somebody from somewhere in Europe, somebody from somewhere in Africa, somebody from the Antipodes, and I make up something like, leaping the boundaries or what next for women, and they speak for 6 to 7 minutes. They can say whatever they like, because the topic means that you can just go for it from your own point of view. And then we have a general discussion, and it means that we can have a discussion with women from all around the world. The Australians come on at 8 p.m. when it's not daylight saving there, and 10 p.m. when it's daylight saving. Somebody comes on from Denver, Colorado at 4 a.m., etc., etc. And we, of course, come on at 11 a.m., which is convenient for us. But anybody who wants to join, just get in touch with Anna and we can put you on the list and let you know.
I think I've shared that in the newsletter sometime, and I will share it again this time. I've been in these sessions, and it's such a feeling of sisterhood and womanhood. It's really nice, actually, to hear different perspectives from all around the world. And yeah, it is really nice. So thank you for that, Jess. And thank you for today. It's been amazing. A lot of information. I think we have a lot to celebrate, and at the same time, a lot to do. And yeah, if you would like to do more, just get in touch and come up with ideas, and let's do something about it. So thank you, everyone. If you have any other questions, I'm sorry we haven't had time. You can send me an email with your question, and we will do as much as we can with just to answer your questions as well, and to keep in touch. So thank you, everyone.
Thank you.
Thank you.
Thanks, Anna. Thank you.
Bye-bye.
Bye. I'm trying to leave. The thing is that I'm trying to leave. There it is. Bye.
Bye. Thank you.
Bye, Trish.